Affidavit by verified declaration. To whom it may concern, whereas the public record is the highest evidence form, I, the undersigned, hereby create a public record in the jurisdiction of the Maine Republic in the United States of America. Plain statement of facts. Fact 1. I have not seen nor been presented with any admissible evidence which demonstrates that the IRS is something other than a collection agency for the non-federal Federal Reserve Bank, and I believe that none exists. Fact 2. I have not seen nor been presented with any admissible evidence which demonstrates that the IRS is something other than a corporation incorporated in the state of Delaware in 1933, and I believe that none exists. Fact 3. I have not seen nor been presented with any admissible evidence which demonstrate that the IRS is something other than a corporation unlawfully acting under color of law as a government agency, and I believe that none exists. Fact 4. I have not seen nor been presented with any admissible evidence which demonstrates that the IRS is not required to adhere to Title 15, Chapter 41, Subchapter B, Section 1962, and I believe that none exists. Undisputed conclusions. Title 15 U.S.C. Chapter 41 Consumer Credit Protection. Subchapter V Debt Collection Practices Section 1692 is an act of Congress designed to protect natural persons. 1692 asserts that the term consumer means any natural person obligated or allegedly obligated to pay any debt from abusive collection agency practices. The IRS is incorporated in Delaware as a collection agency for a Puerto Rico company, the Internal Revenue Tax and Audit Service, IRS, a for-profit General Delaware Corporation, incorporated July 12, 1933, file number 03250-720. The IRS is not part of the United States government. Diversified Metal Products v. Tebow Company. Trust, IRS 93405 EEJL. Several other corporations involved with the IRS are also unlawfully acting under color of law as government agencies. Notice. Notice to the agent is notice to the principal. Plan. Notification of legal responsibility is the first essential of due process of law. Connolly v. General Construction Company, 269 U.S. 385, 391. Your silence stands as consent and tacit approval to this regard. If no reply is delivered within 30 days, you are agreeing to the foregoing and are legally stopped pursuant to Carmine v. Bowen, 64 A 932 1906. Silence activates estoppel. I hereby reserve the right to make amendment to this. Document as necessary in order that the truth may be ascertained and justly determined. If any living body has information that will controvert and overcome this declaration, please advise me in writing by counter-declaration and affidavit form within 30 days from receipt thereof, proving that this affidavit is substantially false. 1. The undersigned do herewith declare, state and say that I am competent by stating the matters set forth herein, and that the contents are true, correct, complete, and admissible as evidence, and not misleading by my best knowledge and belief. This document may be recorded and may be used at the discretion of its issuer under Rule 902 of the Federal Rules of Evidence, including the jurisdiction of the state of Maine and the United States of America. By my hand this day of 2012.